You want $3 million to settle your case. Okay, guess what? The defense is not going to pay you $3 million. Instead, they've told us that they are willing to pay you $2,900,000. What do? You want to know what you do? Come join me on this walk as I share with you the answer to this question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, you sued your doctor claiming that he was careless, causing you significant harm and injury. And now, the doctor has denied all of your allegations. The doctor refuses to accept responsibility for his actions. The doctor refuses to acknowledge that anything he did caused you harm and injury. And then he says, you know what? Even if I did something wrong, whatever I did didn't cause you harm. And then he says, you know what? If I did something wrong and I caused you harm, your injuries really are not as bad as you make them out to be. So now, they fight this case tooth and nail. They refuse to accept responsibility. The doctor and his attorney refuse to go ahead and negotiate. They say, we'll see you at trial. And we say, fine, we'll see you at trial. So now discovery continues throughout the litigation. At the end of discovery, now before your case gets scheduled for trial, the judge tries to go ahead and get settlement discussions going. And after a few weeks, we now have some serious settlement negotiations. We have told the judge that we are willing to accept $3 million in order to settle your case. The defense ultimately comes up with $2.9 million. And now you're faced with a decision. What do you do? The defense has come very, very close to what you are asking for. You have waited now almost 2 to 3 years for resolution of your case. You think in your mind that if you go to trial, a jury is going to give you significantly more money than what it is that you are asking for in a settlement. And you're thinking maybe you go ahead and take the risk to find out what's behind door number 1, meaning a jury verdict, which is unknown. You don't know what the jury's going to do. You may be willing to risk it all. So I turn around to you and I say, okay, let me ask you a question. Do you gamble? Are you the type of person to take your entire life savings, put it on the line on one particular bet? Let's say you play blackjack or roulette or craps. Will you go ahead and put all of that money on one single bet? If you are the type of person to gamble and risk it all, well, guess what? Then you should go to trial. You should go ahead and take a jury verdict, even if it means 2 or 3 weeks of being on trial, of having ups and downs and highs and lows, psychological and emotional highs and lows throughout your trial. You should go ahead and think that, okay, you're going to lose this case, or the jury will ultimately come back and give you less than what you're being offered right now. You can do that. And I guarantee you, if you go to trial, this is exactly what you are going to experience. There will be days where you will feel great. You will feel invincible. You will feel as if the jury is going to give you 10, 20 times more than what the defense is offering you. And you're thinking, there's no possible way you can lose. On the other hand, I now have to bring you back to reality and get you to recognize that you think you have a great case. You think your case is worth so much more. Well, guess what? The jury might not believe you. They might only believe part of your story. They may feel bad for the doctor. The jury could come back with a verdict and give you absolutely nothing and find that the doctor did absolutely nothing wrong. How are you going to feel then? In that case, you're going to feel like crap. Why? Because now you threw it all away. You threw away $2.9 million just to risk the potential of getting significantly more money. What you also don't realize and didn't take into account when you rejected the offer was the likelihood that if the jury came back with a tremendous verdict, that the defense would certainly, with 100% certainty, appeal that verdict. And that could drag out your case for another 1 to 2 years with, again, uncertain results, with the risk that your case could be thrown out, with the risk that you could have a substantial verdict or it could be reduced significantly. And there are many other options that are available to the appellate court. But you didn't bother to take that into account. Instead, you decided to bet it all on one single hand. And you know something? The problem with that thinking is that you don't know what the jury is going to do. Neither does the defense. That's what makes it so risky. It's risky for the defense. It's risky for you as the injured patient. So what do you do in that instance where you are demanding $3 million to settle and the defense has come almost exceedingly close, if not very close, to exactly what you were asking for. Well, I'll tell you what you have to do. You have to have a very, very honest discussion with your attorney to discuss the risks of going forward, to discuss the benefits of going forward, to discussing the risks of going ahead and accepting a settlement like this, knowing full well that your case may be worth more ultimately a few years down the road, or then again, it may be worth less. If a jury comes back and gives you substantially more money than what the defense is offering you, you are going to feel great. You're going to feel amazing. You're going to definitely think that you made the right choice by going ahead to a verdict. The problem is the defense is going to feel like crap, and they will have no choice but to appeal the verdict. And you know, there's also the possibility that when they appeal, the appellate court could turn around and say, you know, we accept the jury's findings that the doctor did something wrong and that the doctor's wrongdoing caused you harm, but we do not accept the amount of money that the jury has given to you. We're going to send this case back down to trial for a brand new trial so the jury can reassess fairly exactly how much your injuries are worth. In that instance, you're going to have to retry this case all over again with a focus on the value of your injuries. And what happens then? Well, if you now go again all the way to verdict, it is possible that the jury will come back with a significantly large enough award that the defense will again appeal, and you could be in a vicious cycle, and this could go on for many, many years. So you have to weigh those risks against the risk of getting guaranteed money, guaranteed lump sum of money in your pocket as a result of the settlement offer. Should you take it? Should you not take it? That's a decision that calls for a detailed, in-depth discussion with your attorney to weigh the risks and advantages of the offer. So why do I share this great information with you? I share it with you to give you a sense of exactly what happens when the defense makes a very substantial settlement offer that comes exceedingly close to exactly what you are asking for. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter happened in New York and you have not yet started a lawsuit, but are thinking of doing so, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.